So, this is not a new thing, only thing the court has affirmed that states have got the powers. Whereas, because of a judgment earlier given by 5 judges in Chinnaya case, that you cannot subcategorize the scheduled caste. That was the judgment in the Chinnaya case. So, now that has been overruled by a 7 judges bench, they say the state has the powers. So, that is the main thing. The other portion of creamy layer among the SCs or STs that has been referred by the judges, it is only an observation, not a judgment. Only the creamy layer at present is being applied on backward classes, which from our federation at the all India level we are opposing continuously that creamy layer concept should be completely removed. And by the present 105 judgment, 105 constitutional amendment, even the creamy layer cannot be applied for backward classes. That is what the judge, many of the legal people, they are observing that because of the 105 judgment, constitutional amendment, the backward classes, the list that is being already applied by the union government and by the state governments. So, the definition of backward classes is as per the list only. The scheduled castes or scheduled tribes, it is being scheduled in the constitution. That is why there was creamy layer was not applied when the Indira Sahni judgment was given in 1992. The court said it is not applicable for SC/ST because there is a definition about the scheduled castes and tribes in the constitution. There was no definition about who are all the backward classes. There is no mention about that backward classes in the constitution when at the time of Indira Sahni judgment of 1992, but by 105 constitutional amendments, whereby the states have been again the powers have been restored to identify the backward classes. The court has the constitutional amendment says that the list that are being applied by the union government and by the states forms the backward classes. So, the judges, many of the legal luminaries feel that a definition has been created, you cannot subcategorize further in the name of creamy layer. That is an observation which we have been taking with the government. That is one part. So, this subcategorization is not a new event that is happening in India. So, some of the people who are speaking against the subcategorization and going to the court, stating that the consolidation of the scheduled caste will be affected. That is one observation by the people who have gone to the court. But basically, the concept of social justice is to ensure that all communities get representation in the power structure. That is the basis, not for employment. It is only a matter of representation. The constitution says only representation. Article 16(4) says, if they are inadequately represented, you can provide reservation. That is what the constitution 16(4) on employment says about that inadequate representation only. So, the reservation means only about representation. Representation where in the power hierarchy, in the governance of the country, the decision making process. So, every community has got a right to demand for a share in the governance of the country. So, when there are various subcastes among the categories, for example, in the backward classes, we are having more than 4,000 castes. In the scheduled caste itself says, the name itself is a plural only, it is not a homogeneous group, not a single caste. There are so many castes among them, where there is also a slight hierarchy, where some communities are getting more share than some other communities. That is what the communities affected by that, they say that we should have a share in that. So, the government which is concerned about social justice have to make or ensure that all these castes get some share in the power hierarchy. That is the idea behind bringing a subcategorization. So, the Tamil Nadu government in 2009, when they brought this Arundhati subcategorization, the idea was that particular groups of called as Arundhatiyas, they do not have adequate representation in the various schemes of the government. So, the government brought on 3% reservation One example I can tell you that prior to that, in the medical admission, which is the toughest one in any area, particularly in Tamil Nadu, getting an admission in the medical college is a tougher one because of the number of seats in the college, because it is limited, unlike engineering colleges, where we are having nearly 540 colleges. So, there is no problem in getting an admission for an engineering seat, but they may be particular about a particular college. That is a different matter, but getting a seat admission for an engineering college in Tamil Nadu is not a very difficult one compared to medical admission. For Arundhathir community, prior to this bringing of this legislation in 2009, they were not able to get any admission in the medical colleges, and in 2000 up to 2014 they were able to get 1 or 2 admissions. After this 2009 legislation, where 3% have been provided to them, in 2015 alone they got 84 positions in medical college. So, that is the improvement or advancement and the impact of this subcategorization of a particular group. So, it is very much necessary that a subcategorization is essential. That is why the government, for some other reason, they brought this Justice Rohini Commission of subcategorization of the backward classes. The reason brought by the present government, the intention is different, but the name given is subcategorization of the backward classes. But when the Justice Rohini Commission, I have been called to give my submissions, I went before the commission and told them that before making a subcategorization among the backward classes, you please have a data. Without data, if you are going to subcategorize, that cannot be a justifiable one, because the Rohini Commission intention was that they will collect the data of employment of the backward classes in various sectors. For example, in the banking industry, in the UPSC, like that, where your 27% will be filled up in the initial stage. So, among this 27%, they will calculate which community has cornered that 27%, and based on that they thought that they can subcategorize the communities based on that positions they occupied. I told them that this cannot be a justifiable process, because your 27% you are giving today, you on a position means some communities are coming inside, particularly one, for example, X community. Among the 100 seats, if they are cornering some 40 positions, and if the commission decides that that community is only cornering all the 40 positions and the remaining communities are able to corner only 60 positions. So, if you are going to subcategorize on the basis of this data, then it will be very fallacious or it will be a wrong process. Then I explained to the commission that X community, what is the percentage of population among the community? Suppose if that community among the 100 people, if they are 40, and if they are able to corner 40, there is no problem in that. If they are 10 and if they are cornering 40, then there is a problem, because they are going beyond the ratio. So, your data is very much essential when you are going to subcategorize. So, I told the commission, you please ask for a data, you ask the government to conduct a caste census. Those commission wrote a letter to the government that in 2011, the then UPA government conducted a socio-economic survey. That data was available, is available with the present government, and they asked for the data. The data was not given to the Rohini Commission, and the Rohini Commission told me that they rely only on the 1931 census. I said, how that you are going to subcategorize a caste based on 1931 census? That is not a correct way. So, I said that you please conduct a census, then go for subcategorization. That is our submission. That is what I told the commission also, and I think the commission has finally given a report, the data, but which we do not know, because it is not in the public domain. The government is reluctant to release the data also. That is one part. Why I am telling? Because when you are going to subcategorize any caste, you should have a data. So, the caste census forms a very integral part in conducting any exercise, not only sub-categorization, for any schemes of the government should have a data. That is a logic, that is a rationale behind doing any schemes. For everything they should have a data, but when it comes to caste census, particularly for the non-SC/ST community caste, the government is very much reluctant. That is the thing. Not only for OBC, I am telling, we are demanding not only for OBC, we say that you conduct a caste census. And when the government, when we questioned the government, present government, the Registrar General of Census is giving a reply that exercise is very difficult, cumbersome, and it gives lot of mistakes, as happened in 2011 caste census, which is not a correct answer given by the government, because the same Registrar General some 2 years back he told that the data given by the caste census survey is 98% accurate, but subsequently they changed the stand and say that nearly 45 lakh inaccuracies are there in the data. That is why we are not able to process that. That is not the correct answer given. Even in the Supreme Court, they are not able to give a proper answer. I have filed a case in the Supreme Court of India demanding the union government to conduct a caste census. It has been being listed continuously, but the government is not coming forward with any affidavit so far in a proper way. They are not ready to appear before the Supreme Court also on this matter. So, this caste census, when it started in the Britishers in 1871, initially they do not calculate based on only this overall caste community like SC, ST, OBC like that. They calculate based on the various subcastes like Brahmins, like that they calculated. So, at that point of time only the nation was able to know how much percentage the Brahmins were there in this country. That was the only exercise done by the time. So, when the first census report came, the people were able to know how much this community population and how they are representing in the various sectors. They were able to compare that, and knowing this, they were very much afraid of this data. Subsequently, they maneuvered the system and they said that hereafter it should not be conducted. Then they started conducting as Hindus like that. Subsequently, they changed that. So, the present decision of the government in not conducting a caste census is based on that fear only, that the dominant caste who is ruling this country, they are afraid of this caste census, because if that caste census is conducted today, even your 10% EWS will be challenged. Already there is a challenge. The government, Supreme Court has asked for the data, the government has not given the data, and if this caste census is done, naturally it will reflect on the legality of 10% EWS also. So, the government is not ready, because the whole government apparatus is dominated by the Brahminical system. They are only ruling this country, all the decision making process is under their control only. So, they know very well, by doing this exercise we are entering into a problem, and they do not want this problem to come. That is why they are saying that various reasons to avoid this caste census. But when the country wants to develop on a social justice pattern, naturally you should have a data, and this sub-categorization is also essential until you reach a level where every apparently it should be seen, or it should be felt by every community that they are also having a part in the governance of the country. That is what we are saying about this caste census and sub-categorization. I have certain questions also been raised, where we have given the answers also. Why the need for a nationwide caste census, because various state governments are now taking that. So, there is some the union government is telling the court that let the state also can conduct like that, but the constitution says that the Census Act of 1948 empowers the union government only to conduct the caste census. States can conduct a survey only, because they do not have any department like census department. Only the union government is having a department, census department is there, a mechanism is there. So, they are only have the responsibility to conduct a census. States are only having a various, they do not have this kind of mechanism. Whatever they do now, they are doing only on their own by involving various people in the government. But one thing here is, by this survey, for example, Bihar has conducted a survey. Within 60 days, they were able to give a data, and that data, nobody has contested about the accuracy of the data. Nobody has contested. Even though the court has stated that you cannot violate 50% ceiling like that, they never said that your data is totally inaccurate. Now, when a state like Bihar can conduct a census so much accurately, why not a union government having a system cannot conduct a census? Now, by this we are questioning the union government, why you are not conducting the caste census when the state can do it so accurately. So, your Registrar General reply that it will create lot of inaccuracies is totally false, because Bihar has proved that. Now, Telangana has given, government has given the order to the commission to complete it within 60 days. So, within 60 days, a government without any mechanism is able to collect a data. Why not a union government having a separate department for this, doing the exercise for so many years on various categories, cannot have a full time exercise, because the column itself very simple. You have to add only one column, caste. The Registrar General says that there are so many subcastes, so that will give a lot of confusion. That is not an issue. Whatever may be the subcaste, you are only combining everything into a single caste. In the already you are having a union list, you are having a state list, all these castes are listed only in that. Already in the nation knows which caste belongs to which group. And moreover, whether he is a literate or illiterate, in India, everybody will know about their caste. There is no problem. Other things they may not be knowing, but a caste everybody knows about them. So, there is no problem, but intentionally, as I said earlier, the intention is, if this data comes, then the nation will know who is dominating the process in this country. That is the main problem of refusing to conduct a caste census, and the subcategorization is another extension of social justice. If you want to have a social justice in this country, you should ensure, as long as this caste system is there, you have to see that all the communities are getting their share in the governance of the country. That is a simple thing. That is what we observe from our Periyar movement angle. We also think like that only. So, this is what I want to share with you. Now, you can ask questions.